Welcome back to Past Law Exam's Criminal Law series. In Part 1, we examined intention. Today, Part 2, recklessness and negligence. Let's get into it. Recklessness is the deliberate running of an unjustified risk of which D was aware. It sits below intention in the hierarchy of fault, but remains subjective. The law looks inward at what D personally foresaw. Three things must be established. D was aware of a risk. That risk was unreasonable to take, and D proceeded regardless. Cunningham, 1957. D ripped a gas meter from a wall to steal money inside. Gas escaped, partially asphyxiating a neighbour. Charged under Section 23 of the Offences Against the Person Act, 1861. Trial judge directed that malicious meant wicked. Conviction quashed. The Court of Appeal confirmed. Malicious requires either intention or recklessness, meaning D foresaw the risk and proceeded regardless. Subjective test established. Parker, 1977. D slammed a telephone handset in temper, damaging it. Claimed he had not foreseen the risk. Conviction upheld. Deliberately closing the mind to an obvious risk is the equivalent of knowledge. Stephenson, 1979. A schizophrenic vagrant lit a fire inside a haystack to keep warm. The haystack was destroyed. Psychiatric evidence showed he could not appreciate the risk. Conviction quashed. Genuine incapacity to foresee the risk negates recklessness. Parker and Stephenson together draw the boundaries. Closing your mind to an obvious risk is recklessness. Genuine incapacity to foresee is not. Brady, 2006. D drunk. Climbed over safety railings at a nightclub, fell onto the dance floor, seriously injuring a woman below. Charged under Section 20 of the Offences Against the Person Act, 1861. Court of Appeal confirmed. D is reckless if conscious of an unjustified risk and proceeds regardless, but also reckless if unaware only because of voluntary intoxication, and would have been aware had they been sober. Self-induced intoxication provides no escape. Caldwell, 1982. D drunk. Set fire to a hotel. Guests were present. Argued the risk never crossed his mind. House of Lords introduced an objective test. D is reckless if they do an act creating an obvious risk and either gave no thought to that risk or recognised it and proceeded. No longer necessary to prove D actually foresaw the risk. Heavily criticised. RVG, 2003. Two boys, aged 11 and 12, lit newspapers in the backyard of a shop and threw them under a wheelie bin, expecting the fire to burn out. It spread. The shop was gutted. Approximately £1 million in damage. The House of Lords overruled Caldwell. An obvious risk to a reasonable adult is not necessarily obvious to an 11-year-old. Subjective test restored. D acts recklessly where they are aware of a risk, and it is in the circumstances known to them unreasonable to take it. Recklessness is subjective. D must actually foresee the risk. Finally, negligence, an objective fault element. No awareness of risk required. The Law Commission defines negligence as the failure to exercise such care, skill, or foresight as a reasonable man in his situation would exercise. Two key distinctions. All recklessness is negligence. Recklessness is negligence with added fault, awareness of the risk. But not all negligence is recklessness. Negligence requires no awareness whatsoever. Quick recap. Recklessness, subjective. D must foresee the risk. Cunningham, subjective test established. Parker. Closing the mind to obvious risk is recklessness. Stephenson. Genuine incapacity negates recklessness. Brady. Voluntary intoxication, no escape. Caldwell. Objective test introduced, overruled. RVG. Subjective test restored. Negligence. Objective. No awareness required. Failure to meet the standard of the reasonable man. All recklessness is negligence. Not all negligence is recklessness. For more exam-focused breakdowns on your University of London LLB, visit passlawexams.com. Subscribe to the Pass Law Exams YouTube channel because passing is not just a possibility, it is the only option.